Hello, everyone, and welcome back to the Coalition Radio Network with Chaz Calenda, attorney at law. This is episode 3 in an ongoing series discussing emerging legal issues in Rhode Island and throughout the United States. In particular, we're going to be talking about restoring and reclaiming some of our civil liberties, which have been under attack recently with recent legislation and court actions. Tonight, specifically, we're going to be talking about restoring your fundamental right, I should say, to owning and possessing a firearm after certain mental health events may have prevented you from owning one. And with me tonight to help me discuss that is Pat Ford and Daryl Gould, who will be facilitating our conversations. Pat and Daryl, thank you for joining me tonight.
Hey, thanks for having us, buddy. This is great.
Yeah. Thank you very much, Chaz.
Not a problem. And I'm glad I could have two people with as much experience talking about these issues as both of you have. One of the issues I wanted to talk about is one that I'm facing right now in my legal career, is one where people who have had a history of mental health illnesses, perhaps in their past, very distant past, are having trouble finding their way to possessing a firearm, which, as probably both of you know, the United States Supreme Court has previously ruled to be a fundamental constitutional right to have and possess a firearm in your own home for your own self-defense. Particularly since the General Assembly a couple of years ago, or maybe it was last year, I believe, changed the law which required the hometown chief of police to conduct a state background check when somebody purchased a firearm. There's been some difficulty with individuals attempting to purchase firearms throughout the state of Rhode Island. And I wanted to get some thoughts on some of the issues that you guys have seen going through that, because I have seen some widely different approaches taken by different towns, particularly some towns on the East Bay, as to making people jump through all sorts of hoops just to purchase and possess a firearm when they are legally able to do so. Daryl or Pat, you want to share any of your stories that you may have?
Daryl, why don't you go? Why don't you go first?
No problem. So, as you were alluding to, Chaz, the red flag law, and that was, there were a lot of us in yellow shirts up at the State House who saw the unforeseen consequences rattling down the tracks at us, the lack of due process in the original revs of the legislation, which are obviously things that anyone, even if you're not a firearm rights advocate, these are just, like you were saying, these are just, these are our rights as individuals, and we need to treat them with the respect they deserve. So basically, the challenge, one of the biggest challenges I see, is that the case down in Westerly, which precipitated this whole red flag thing, was there was a gentleman who, according to local police, may have been mentally unstable. They were very familiar with him. He bought a firearm in a different town, and historically where the gun shop was located was where that police department rather would do your background check. So what I think's kind of happened on the East Bay is we don't have any gun shops. So we have a lot of towns that historically they're not familiar with gun laws. There's new legislation that's always coming out, and are they keeping up with it? But they just don't have a lot of experience doing it. And I think there's a total lack of training when it comes to bringing law enforcement up to speed on the legislation that's actually in play. But we've seen, myself included, I own a number of firearms, and I had recently was documenting a private sale through a gun dealer. And when the background check went to Warren, they refused it based upon what they described as concerns about my mental well-being. Not that those aren't unfounded on a social media level.
Be careful what you say. Be careful what you say, Daryl.
So no, I am of sound mind and body. So ultimately, what happened was they they said there was actually a police report that they referenced as justification, and they said the based on what was in this police report, we have concerns and we're not going to allow you to purchase this firearm. They even went so far to say, Daryl, we know you have other guns, and we're not looking to take those away. We just aren't allowing you to buy a new one. The
Which
logic
right there,
behind that
Daryl,
is lost on me.
yeah, yeah, right there, Daryl, is an internal inconsistency because if they are denying you the right to purchase a firearm, they would also have to tell you that you have no legal right to possess any firearm because the standard is the same. And I've actually encountered that with several different departments, and it's not just on the East Bay. It's some places like Gloucester or North Smithfield. There, I'm running into the same predicament that you've just described. They're saying, well, we're not going to try to take your guns, but you can't purchase anymore, which is inconsistent with existing state law. Pat, are you familiar with this provision that since it's been put into effect, the so-called hometown chiefs background investigations?
Yeah, no, and my favorite two words in the Rhode Island universe are arbitrary and capricious. And what it strikes me is that they've done is that particularly since police chiefs are more often than not serve at the discretion of the mayor, then the internal politics, if you will, of the mayor then drop down into, if you will, a constitutional right at the municipal level. And I don't think this is quite the intent of the Constitution, that some mayor du jour, who may have their own internal biases, would impact the fundamental constitutional right. I mean, we don't license free speech on the herewith of a mayor, an elected official, and we certainly the right to protection from search and seizure is the Fourth Amendment is not based on the internal politics of an elected official. So why would we assume that the constitutional freedom, and as I always say, I'm a post-constitutional kind of guy, the natural born right of an individual is based on the whims of the political fancies of another individual? It's absolutely atrocious in my mind.
It is, and the statute actually couldn't be clearer if you actually read it. 1147-35, which is the statute that was amended last year, that requires the background checks be done by the local chief of police from the town from where you reside, has not changed in any other respect. So really, their only duty at this point, when you're going to a firearms dealer to purchase a firearm, their duty is to determine whether or not you are disqualified under state law, because there's already a federal background check that's done at the dealership. They run you in the next background check. That's done on the spot or within a day or two. And the chief of police, they have a duty to determine whether or not you are disqualified under Rhode Island state law under 1147-5, which is possession after being declared a prohibited person, 1147-6, being declared a prohibited person by virtue of mental defect, 1147-7, which means you lied on your it's another section, excuse me, a lie on your application essentially, or whether or not you have some other disqualifying event like you're a habitual drunkard or you're a habitual drug user. Those are the only things that a state background check the chiefs of police are supposed to be checking for. But they're using these reports like you referenced, Daryl. They're, in your case, I don't know how old these reports were, but I have clients that come to me routinely. They said, 20 years ago, the so-and-so police department went out to your home to do a wellness check because you didn't answer your phone. We went out there, no charges were filed, everything was okay, everyone was all right. We left, there was no problem, but it's marked as a wellness check. And they're using that to deny people the ability to buy firearms at this point. And that's just simply not part of the statute. And people are having to resort to hire lawyers like me to exercise their fundamental constitutional rights, which Pat, I couldn't agree more that, we have fundamental, and I would agree with you in your terminology, natural rights that are, have been bestowed upon us by virtue of being human beings by virtue of being Americans that are being trampled on at the whims of the arbitrary and capricious decisions of certain public officials. And I think that's a very troubling trend.
Well, and again, the beauty of this show, by the way, folks, and if you haven't, my name is Pat Ford. This is, if you will, you often hear the term when listening to media, it's the opinion of station management. Well, I'm station management, and it's my opinion. But what's great about this show is that we are able in this format to separate, if you will, fact from fiction, urban legends and myths to legal reality. And the ability to have an attorney, not just like someone like myself who's literally an expert and tries to play one on the radio, but literally be able to examine as a legal issue purely in the sense of the law. So my question, attorney, is that, you often hear the conversation about the difference between will and shall. And you hear the conversation sometimes circulating around the notion that they must process this unless there is a substantial or a substantiated legal issue, and that discretion is not introduced. It's simply either A or B. Is that the case in this statute? And how have these folks been able to carve out, let's call them activist police chiefs, if you will, in the sense of the law, how have they been able to carve out this notion that they've got discretionary authority over the right to bear arms?
Well, the shall and may usually comes up in the context of issuing a carry permit, but in the context of buying a firearm or purchasing or possessing a firearm, there really is no discretion, because if you look at subsection 2 of 114735, the chief of police's only duty is to ascertain whether or not you are prohibited from possessing a firearm under 1147.5, 1147.6, 1147.7, or 1147.23. And just to break those down real quick, 1147.5, you got a previous conviction for a crime of violence. 1147.6, you have certain mental health conditions. You've been declared mentally incompetent, criminally insane, adjudicated in the mental health court as being involuntarily committed to a mental hospital. 1147.7 deals with being an alien in possession of a firearm. And 1147.23 means you lied on your application. If the chief of police runs a background check on you and none of those provisions come into place, he shall certify your ability to purchase a firearm. And the fact that they may have concerns about other things that you may have done in your life, other actions that may have come up in your past, if they believe that you are an imminent, and in the key word here is imminent, threat to yourself or others, they have a duty to file a red flag petition, because that is the only other way to keep you from possessing a firearm, because it's not under 1147.35, which is the hometown chief law.
So
now, if I'm correct, Chaz, when they do deem you unfit, if it's something, and I don't know if this applies for some of the other provisions, but they have, due process is introduced when they have to seek the opinion of a judge to get I think it's protective safety order, which basically says, and my understanding is, basically puts a pause on everything, and then you have to prove your mental, wherewithal, and then when you do that, you would then, regain your right, for lack of a better term.
Well, unfortunately, on the state system, there really is no formal process to appeal the chief of police denial of your ability to purchase a firearm. If they deny it, you have to literally try to negotiate with them or take it to court to try to sue them for specific performance. It's unfortunate that I've seen bills in the last few years as far as maybe they're more dealing with carry permit provisions, but to create a cause of action in the Superior Court, which will allow people to have a definitive path for judicial review to review these decisions. That has not come to pass either under the carry permit provision or the purchase provision. And I've been advocating for that. I've talked to several state reps, state senators about trying to carve out that specific cause of action in the Superior Court, which would allow people to go to court on a specific cause of action to overturn the chief's decision.
I think one of the challenges, and this is just my personal experience, is almost this culture with the police where you see this transition as you go down the path with them on these types of issues. So when they first engaged me to ask some questions, I had about a 25 minute interview with the detective who was doing my background check, going back 30 years into my history and literally checking everything. So it starts out and they're your buddy and they're trying to help you. And it's just friendly conversation. And if you start, all of a sudden you get to that point of conflict, they're not going to issue the firearm, the ability to purchase. So now all of a sudden you might stand your ground, and that's where they just run so much interference that you have two choices. You either go away with your tail between your legs because it's not that important, or you pony up the money and you get counsel and you go after them. And a lot of people just find that distasteful, so they just go away and the behavior is allowed to continue.
Yeah, and Pat, I'd ask you to weigh in on this, because I think that actually that situation is a major issue for civil liberties, and I know that that's a concern of yours. It should be a concern of everybody's. When you have people who are just kind of throwing up their hands because of the interference that's just being run, as Daryl has just described, and say, you know what, I don't have the money to pay for a lawyer. I don't have the time to fight the police. Not that they want to fight the police. They're otherwise law-abiding citizens entitled to possess these firearms. Is it a de facto denial of somebody's civil rights that these decisions are being made in that manner?
Absolutely. And it's a concern on a couple of levels, because for very often for folks, this is sort of a transitional moment. And I think Daryl knows where I'm going with this. It's no secret that I'll say this quietly. It's maybe just between us. I'm a libertarian. And so for many folks, I call this a transformative moment, because this is the first time that an organization that they've traditionally believed in and stood solidly behind takes away one of their fundamental civil rights. And that is, of course, this is their first, if you will, first time that they're on and I'll say the air quotes, wrong side of the police department. And it's frustrating and infuriating to them, because these are folks who traditionally obeyed the letter of the law. It's been pointed out on the show by a couple of folks who I consider subject matter experts that people who have concealed carry permits are just astonishingly scrupulous, in part because they treasure that concealed carry permit, and in the state of Rhode Island, the awesome, if you will, responsibility that a otherwise difficult constitutional culture permits them. So that's the first issue. And then the second issue, of course, is we have a number of people in this state who are part of one type of, if you will, minority or another. And I've long for advocated for folks in the LGBTQIA community to embrace, if you will, firearm culture solely for purposes of self-defense, because as a people, they are often targeted indiscriminately at a higher level than you'll see in traditional society. So all of a sudden, you're taking a group for whom it can be argued statistically. I'm taking the emotion out of it. I have many friends who are part of that community and are going through that sort of mental transition now, as you again have this this terrible series of tragedies, particularly involving people in the trans community. So you're targeting, and very often you're not targeting the white hunter, if you will, that prototype, but the people that this makes this difficult for are people who live in areas and where street violence is an issue, and for people whom, because of the, if you will, the culture, the social culture, they are often picked upon. So in a very real sense, the state and its delegated authorities are being bullies of the worst possible type, and you're endangering people simply because of your own political prejudices. And that, by definition, to me, is a violation of someone's civil liberties and civil rights. I would almost, if I didn't, I would almost call it a hate crime that our own legal system is perpetuating on them. And it's especially glaring because in many cases they're not able to afford these people the protection that they deserve. So I find it infuriating, absolutely infuriating.
Second Amendment should be the biggest trans issue, LGBTQ issue, feminist issue. You're talking about the most marginalized people and most vulnerable people in our population. They should have just as much right, if not more, to defend themselves from a greater risk than the rest of us face on an average day.
Yeah, and it often is the most marginalized and oppressed groups that are feeling the brunt of this. And unfortunately, people who some of them are of limited means financially, and by creating these barriers and forcing them to go talk to an attorney. And although I like to think my prices are reasonable, I can't work for free. Who can? There's not too many of us who can, but therefore you're forcing them to go get legal counsel to try to fight against the state who should be protecting their rights, and they're just simply not doing it. And you're really putting them in a position of, am I going to infuriate my chief of police? Am I going to infuriate the attorney general? Am I going to infuriate any members of law enforcement if I push this? And most people just throw up their arms and say, you know what, it's not worth it for me. And at that point, I think we've gone into dangerous territory, because now the state has, even if they haven't passed a law to do it, the state has basically stripped us of what are our natural and fundamental rights.
And let's take it a step further. Most folks in America currently are still been conditioned and been raised to, if you will, respect the authority figures in the community. You may have picked just two people who, as guests, are probably what's the term? The antithesis of that? I don't know. We'll play that. So for someone like myself, or from what I know of my the other guests on this show, we routinely flout that authority intentionally. But for the average person standing up against a police chief, who particularly in small towns in New England, really represent the face first of the government, it's no small matter to challenge their authority. And and the culture that exists in many of these towns can be quite damning on those folks who do. You've taken the constitutional and brought it into the framework, if you will, of the personal. And that's
it's true, Pat.
Terrible.
It's true. And I'll tell you, and it's not just the everyday people. It's an intimidating process for, I've been trying cases for 15 years in front of juries and judges in this state. And just yesterday, I sat down in a police department. I'm not going to name the police department, but sat down with the chief of police to go over this, these very issues relating to somebody's ability to purchase and potentially carry a firearm. And for 2 hours, I sat with this police chief and debated which was his gut feeling that this person, could be a potential problem. This person probably isn't the right person to have it because of whatever interactions they've ever had. None of them are criminal. None of them are mental health. None of them are drug related or alcohol related or domestic crime related. And, trying, even for me as a lawyer, to try to explain to the chief of police that, I appreciate your intimate knowledge of these people, but, there is a law that governs this process, and it has to be the rule of law that wins out in these situations, regardless of tragedies that have happened, regardless of, people who have slipped through the cracks. If we don't have the rule of law, we have nothing. And that's my mantra, is that, I'm a rule of law guy. And whether I agree with that law or disagree with that law, we have an obligation to follow it, as long as it's not trampling on our constitutional rights.
Well, and attorney, let me ask you a question, if I may. We are increasingly moving into a territory where we are using essentially predictive criminal justice. We are attempting to, based on, if you will, the quote unquote character of the individual, deciding whether or not we should effectively prosecute them in some way or another, for a crime they may commit in the future. And that was touched upon, again in this most current range of of legislation considered, on Gun Day, when we took 30 or 40 or 500 pieces of legislation and gave people 3 to 4 seconds to comment on each. How dangerous is this, and are you seeing this anecdotally in other parts of the country, or is once again Rhode Island the bleeding edge of constitutional restrictions?
I'm certainly seeing it throughout Rhode Island, and I didn't know that Minority Report was not a work of fiction. I'll be honest with you on that. But but that's what it's really become. It's like we're trying to predict what somebody might do in the future based on whatever little actions or past history these people may have, which is not criminal, not domestic, not drug related, not mental health. So I mean, we're never going to be able to prevent every tragedy that happens. I'm not saying we shouldn't try. I'm not saying we shouldn't care about those tragedies. I'm saying you can't, the rules, if we go to court and you're trying to introduce evidence of somebody's past bad character means that they did something, that they committed some crime, or they're going to do something again in the future, that would not be allowed. To be laughed out of court. It's propensity evidence, which is never allowed. So I don't know why we allow it when we're dealing with our fundamental constitutional rights. And Daryl, I think your story as a person who's gone through this is a telling one, because you are as far as I can tell, an everyday citizen. You're not a person out there. You're not a person out there attacking police. You're not a person out there who's a career criminal. I don't understand what why you would have to go sit down and have an interview, a 30-minute interview with the chief of police to buy a firearm. I've never even, I'll be honest with you, it's the first time I've ever heard that for a purchase of a firearm.
And they've actually, what's interesting is, and I believe we have some people who might not have the biggest of brains, but they have a very small book that they try and follow on a daily basis. So they referenced this report. And so obviously I wanted to get an idea as far as what was in this report and who made it. And so I filled out the APRA request for it. And as you know, they have 10 days to respond. On the 10th day at 5:15, the Warren police officer delivered to my apartment the denial letter stating that because so there was a report filed, again, I don't know what's in it, and they are refusing to release the file or the report to me because they said it was never validated, justified, or investigated. And because there is private information of the claimant in it, they are under no obligation to share that with the general public because nothing ever came of it. So I can't even get the documentation they're using to prevent me from buying the gun.
I wonder what the entity who would have the ability to overrule them, the Attorney General, if you filed a complaint with the Attorney General, I wonder what the Attorney General would say about that. Pat, do you have any ideas what the Attorney General, Peter Noronha, would say about that denial of an APRA request that is basically seeking information which is being used against a person from exercising a fundamental constitutional right?
Fat, dumb, and stupid is no way to go through life, young man. 0.0. The Attorney General, and this is my statement, not the statement of my guest, it seems to be running a Dean Wormer like campus kangaroo court in terms of just about everything. So I'm not expecting much other than the usual pablum that is spewed across the state. If one were to diagram his response, he would probably be filled with cliches, non sequiturs, and the occasional, if you will, blanket statement. I'm not expecting much. We get a lot of good for the communities, and I guess the other response is he'd probably try to find some way to put it into a grand jury so that they wouldn't have to comment at all. That's the other response. So
if only we had a great candidate that we could get behind for Attorney General in this state.
Yeah.
If
Uh,
only. And Pat, I'm impressed you were listening when we had our conversation because, as you just alluded to, the grand jury is the all-purpose shield that the attorney general can hide behind, so they never have to comment on anything. So
yeah.
let me just put it into the grand jury. No true bill. I'm sorry. The rules do not let me comment on why, how, what happened, or who showed up behind that attorney general behind that grand jury proceeding. It's the
Right.
biggest trick that prosecutors use. They hide behind the grand jury, in particular in Rhode Island, because it's the most cases never have to see a grand jury unless you're facing life imprisonment. So to me, I 100% agree that that would probably be the response, and it's a poor one because this attorney general has been sued himself by a law student, if I'm not mistaken,
Right.
for trying to charge excess fees for an app based on an APA request. I know this is kind of veering off the subject, but I just found that to be a little bit ironic.
No, that in fact, that young lady appeared here on the coalition, a young woman, very, very bright, and interestingly enough, I think represents a whole new breed of activists. A graduate, or I'm sorry, a student at Roger Williams University Law, and it's and she's part of the immigration group there that practices pro bono immigration law for a number of people. So it's there's hope there, but what we've got this government in place which is erecting obstacles at literally every level for even the exercise of the most basic rights. So my question, Chaz, is what's the step-by-step process? Let's take Daryl as an example. What should Daryl do right now? He is.
I'm always made an example of.
Yeah. if Jazz, don't even ask. But what would Daryl do? WWDD. What would Daryl do in this situation?
Daryl, this is not my legal, this is not professional legal advice. This is just my commenting. But you, at this point, if they're denying you the ability to purchase a firearm, your only recourse is to seek judicial intervention, and that is no small task. And it's debatable whether or not that there's an action in the Superior Court where you can take, or you have to go directly to the Supreme Court, as you do when the police chiefs or the attorney general denies you a ability to have a gun carry permit. As you know, if you're denied of the ability to have a permit by a police chief or the attorney general, your action lies in the Supreme Court of Rhode Island, and that is a daunting experience even for well-seasoned attorneys. And there are very few of us, very few attorneys out there who actually even practice in the Supreme Court, who have seen the inside of the Supreme Court since the day they were sworn in. So it's that's one of the challenges, and quite frankly, that kind of leads me into one of the other situations that we're facing here, where people are being denied their rights in a way where the government has set up a process to get your rights back. You've lost your rights to possess a firearm because you have perhaps a mental health disorder that disqualifies you under federal and state law. You've lost your right to possess a firearm. But Rhode Island, several years ago, I think it was 5 or 6 years ago, they passed 1147-63, which created the Relief from Disqualifiers Board, which if you had a mental health disqualifier and you were not able to possess or own a firearm, now you are able, theoretically, you are able to petition this board for free and have them consider whether or not you have overcome that mental health disability so you can safely possess and own firearms. I have a client right now who is attempting to use that statute to get her rights back to simply own a firearm based on a mental health incident back in 2006, 2007. She has her doctors all saying that she's fine, she's overcome her situation, which is great. And I think that's something that we all want to promote, is that we don't want to have people stigmatized who have mental health issues, who have otherwise sought treatment and successfully treated. But this woman has not been able to petition that board because the board doesn't exist. The board doesn't exist, and I think the Providence Journal did a piece on that. And I don't want to slam the Providence Journal, but one of the few pieces of good journalism I've seen around here in the last last few years. In January of 2020, they're talking about this board. They've never heard a petition. It's because they don't exist. I submitted APRA requests to the Attorney General and the Governor's office when it was Governor Raimondo, asking, who have you appointed, Governor, to sit on this board? There's supposed to be 5 members, one of which is the Attorney General or his designee, one of which is the Director of the Department of Behavioral Health and Disabilities. The other 2 are a psychiatrist, a psychologist, and then there's a law enforcement member. Right now, there are no members of that board. There is no place to submit that petition. So my client had to hire me at great expense, and we are going to have to file suit in the Superior Court against the state of Rhode Island because this person cannot even exercise their opportunity to get their fundamental rights back. And Pat and Daryl, I'd be interested to know your take on that. Are you surprised that this board that was created by statute does not even exist?
All you have to do is ask Blake Philippi about the non-existent boards that exist in this state and the power that they do or don't wield over us. So it doesn't surprise me.
No, and it's my understanding, and this was from a couple of years ago, that there's also supposed to be a lemon law board for vehicles in the state. And a few years ago, and please PolitiFact me, please prove me wrong, but in the state of Massachusetts, a lemon law is alive and well. The lemon law for vehicles can actually be a way for both the dealership and the consumer to get relief. So it in its own way, it can be quite a restorative process. It's one of those few areas of government where you could actually potentially have a win-win. But to your point, if the board is not staffed, if the board is not in force, you're sitting there and it's Kafkaesque what happens in Rhode Island government. It's absolutely Kafkaesque. The circular logic that exists in terms of addressing anyone. I'm a pretty well-traveled kind of guy, and I've lived and done business and worked with people in a variety of forms. There's a tendency in most states to say, we're the worst at this, we're the worst at that. No, I got to tell you, former New Yorker, New Jersey, Connecticut, no, we're the worst on absolutely every level. And I know that makes me a negative person.
It's really too bad though, because I did an interview with a student at Rhode Island College who's a journalism major, and the last question he asked me is, what do you think Rhode Island is known for best? And I said, unfortunately, it's known for its reputation for corruption and incompetence in government. And I think that's an unfortunate and telling situation here, because if we have a government that's run that way so poorly that's the first thing that comes to mind, and from a person, I'm not trying to toot my own horn, but I consider myself a fairly educated person. I don't just parrot talking points that I hear on the news or talk shows, but that's the first thing that pops in my mind, and it's got to be the first thing that pops in most people's mind, because it's just gone on for decades and decades. And it is one of the reasons, Daryl, and I know I appreciate you alluding to it earlier, that I am running for Attorney General in 2022, because I can't bear to see it anymore in a position as important as the Attorney General, who's supposed to be there to enforce the law, who's supposed to be there to fight for Rhode Islanders' rights, to sit back and basically take no action and make you fight and make the common person fight more against the government.
Yeah, and let me just, if I can clarify one of the current considerations that's being held for study. Is it true that, in effect, the Attorney General has attempted to make their own power grab with result to permitting, and would like then to take, if you will, that extra legal authority, and it is extra legal, out of the hands of the local police, the local gendarme, and bring it up to the Attorney General's office? Can that be so?
That is so, and apparently the current attorney general has confused his role with that of a legislator or the governor, because at last I checked, the attorney general doesn't make policy; he enforces the law. But this bill was submitted on behalf of Attorney General Peter Nerona that would strip the police chiefs from any ability to issue concealed carry permits to everyday persons. And the reason why he's doing that is because, Pat, I'm sure you know this, and Daryl, I'm sure you know this. The Attorney General may issue you a permit if he finds you have a need for it. It's almost completely discretionary, and it's nearly impossible to overturn in judicial review. Anybody who's read Mosby versus Devine knows that. That's the case that the Rhode Island Supreme Court decided in 2001. But it takes away the shall issue path for people seeking permits to go through the local police chiefs to get their permits. It's a totally different statute. It's a totally different standard. And the Attorney General, by submitting that bill, if that bill were to become law, you would no longer have the shall issue path for getting a gun permit in the state of Rhode Island, which I think there would be some constitutional issues, as alluded to by the Rhode Island Supreme Court back in 2001, if you don't have the shall issue path. But the reason why they upheld the Attorney General's denial in that case back in 2001 was because they said there is a path for people to get a permit, a carry permit, and it is through the local authority, and that's a shall issue path. So you take that away, there's going to be legal challenges, and I think ultimately that's going to end up a real perhaps a seminal case on Second Amendment law in Rhode Island, the Rhode Island constitutional counterpart.
But here's and Chaz, you and I have had this conversation before offline. When folks hear about a terrible ruling or a terrible law, they often talk about, well, that'll never stand, and I guess the cliche du jour is constitutional muster. But in order to get it to be turned down, if you will, on constitutional muster, which is certainly no guarantee in an era of activist judges, in an era of politically appointed justice, in an era where, let's just say, the current regime that's been in power for 80 years is appointed justice. I think you get the point. It's it's the expense, the time, having standing, and then the time again, and then the expense again of fighting for something like that can effectively put a cloud over someone's constitutional rights for a generation, can't it?
I think we are the perfect example. This state, Rhode Island, is the perfect example of that. It's the process, Daryl and I were talking about earlier, to go to the Supreme Court and ask them. Basically, it's called a petition for writ of certiorari, and it's a discretionary petition. It's a discretionary petition that the Supreme Court can accept or reject, and they can do it based on whatever their whim is. You need at least three justices to agree to accept the petition. And if they don't have to do it, but the process to do it, to get them to issue a show cause order to get the other side to respond is a daunting one. And then once you get that, you have to brief it. You have to potentially orally argue it in front of the justices, and it can take years for them to issue a decision. And you're right, Pat. There is no guarantee that there's going to be a ruling in your favor, and you risk making bad law, especially, and I'm not saying this about any particular justice, so I want to make that particular clear. I'm not saying this about anyone in particular, but you do risk making bad law when you go in front of a court that maybe perhaps is not sympathetic to your position.
Right. And so essentially you institutionalize politically based, politically charged laws through a politically enabled system. And my understanding is, in terms of the certiorari process, whether it be at the state Supreme Court level or the federal Supreme Court level, there is no appeal, is there?
No. Well, in the state Supreme Court level, there could potentially, if it touches on a federal constitutional right, there could potentially be a request to the United States Supreme Court for a petition for writ of certiorari to review the state Supreme Court ruling. But that is exceptionally rare. You don't see that very often. It is difficult to get the state Supreme Court to do it. and just magnify that by about 1,000 times to try to get the United States Supreme Court to do it.
And I guess maybe you could give us another lesson, Attorney Calenda, and maybe this is a great way to sort of bring it to a close for tonight. The Rhode Island, the state attorney general, not the federal attorney general, but the duly elected attorney general for the state of Rhode Island. Who, as an attorney, does he represent?
He represents the state and its people. He has an independent constitutional duty to not only uphold and enforce the laws of the state of Rhode Island, he has an independent constitutional duty to make sure that the rights of Rhode Islanders are being protected. Not just some Rhode Islanders, not certain favored groups, not certain groups at all. He has an obligation to make sure the laws are enforced justly, fairly, and in everybody's best interest. So it's not just, somebody files suit against the state of Rhode Island or the governor or some other state officer that he has to come in there and jump in there to defend it. He has an independent duty to make sure Rhode Islanders are protected. And when you exercise the duties of that office and the powers of that office, which are immense, which are virtually unchecked, in a political manner, you have, in my opinion, abdicated your constitutional duty as the Attorney General of the state.
And if I can clarify that point, elegantly said, by the way, you're not the governor's attorney, are you?
Certainly not personally, but there are times where you have to act as the governor's attorney in the capacity of their role as the governor.
Right. But certainly not in terms of the governor as someone who is, if you will, challenging the rights of the citizens of the state.
Right, correct, and that's the point I've been making with a lot of these COVID restrictions from the executive orders that have come down from the governor's office, from the Department of Health, that the Attorney General doesn't answer to the governor. The Attorney General is not appointed by the governor, unlike on the federal level where the Attorney General is appointed by the president. This Attorney General in the state of Rhode Island is an independent constitutional office, and he has a duty. If he believes that the rights of Rhode Islanders are being trampled upon, in my opinion, he has a duty to take action. He has standing as the state attorney general to intervene in any case to make sure the rights of Rhode Islanders are being protected, just like he did in a lot of these environmental cases that we've seen come up recently in Jamestown and Block Island. He intervened. He was not part of those cases originally. Attorney General Noronha intervened because he felt it was in Rhode Islanders' best interest. Now we can debate the merits of that, but there's my point. He made my point for me because he felt it was his obligation to make sure that Rhode Islanders were protected from this threat to the environment of Rhode Island in those cases. Wow.
I understand that you have someone special coming on next week. What's next up on the agenda?
I am thrilled to say that I'm going to have the queen of guns, the queen of firearms in the state of Rhode Island. Daria Bruno is going to be my guest on episode 4 next week. And I can't say enough good things about Daria. She has done so many good things for the community, the Second Amendment community here in Rhode Island. She's qualified me on the range more times than I can count. I've been on her radio show and she was on the radio many times. I even did an internship with her when she used to be on B101, the oldie station, back in the 90s. So I'm excited to talk about some gun laws and some upcoming issues on the Second Amendment with her next week.
Outstanding. I'm going to put on my station management hat for a second. The goal of this network was to be able to support shows and forums like this, where we could sort of swim through the morass of government, the morass of conventional wisdom, the morass of the urban myths and legends that sort of perpetuate and perpetrate our lives here as Rhode Islanders and as Southern New Englanders and as Americans. And I can't tell you, Chaz, how proud I am to have you on our network. Doing a weekly show, same bat time, same bat station, every week. here at 8 o'clock, schedule permitting. We'll occasionally do the replays. We've already building up if you will, a backlog of material that we can go back to if you have to travel or if your legal, if you will, requirements / responsibilities take you off the air. But Rhode Islanders are craving this type of information and this type of realistic yet accessible discussion of the laws. Because I'll have you close this out, but the urban legends, the myths, they don't matter. It's what's on paper. It's what you can actually do, and it's what you have practical access to that really is what's going to save you as an individual, isn't it?
It absolutely is, Pat. And you know what? Unfortunately, one part of your statement that I want to say, urban myths and legends, unfortunately, do have a very strong hold here in Rhode Island, and people are, people do sometimes are afraid to act because of those urban legends. I want to help get those urban legends and myths clarified and give people ready access to information that they can use to better their lives. And that's one of the reasons why I'm so happy that you've allowed me this time on Wednesday nights to address anybody who's interested in these issues, to listen to what I have to say, listen to our guests. I'm so glad that I had you and Daryl here tonight to be able to have this lively discussion on our Second Amendment rights and what Rhode Island is doing to unfortunately impinge upon them. But this will obviously bring our episode 3 to a close. And I'd like to say thank you again to all of you who are watching us.
How can folks reach out to you in the real world if they need your help?
Right now, you're looking for legal help. You can reach me at the law firm of Inman and Torgy. It's 1500 Nooseneck Hill Road in Coventry, 401-823-9200. You can email me at Chas, CHAS, at Chas, the number 4ag.com. I'm a accessible person. I'm happy to email with anybody, answer questions not only about legal issues, but about my platform for campaign for Attorney General. So I encourage it, and I think that transparency is the best sunlight we can have here, and especially in a state like Rhode Island.
Thank you very much, buddy. And
thank you all.
Go right ahead. Bring us off the air. I'm used to being the host.
Yeah,
sorry.
Thank you. Yeah, no, I appreciate it, Pat. And I'd like to thank everybody once again for joining me, Chas Calenda, attorney at law. This was episode 3. I look forward to seeing you all on episode 4 next week when I have Daria Bruno. And I hope everybody has a great week, and good night.
Good night, folks.
Night, everybody.